is actually just a brief. So I filed a motion, and which includes the motion itself and a brief. And the brief has got all the good stuff in it. So we'll just go through the brief. And now it's on YouTube. I'm not seeing any viewers yet, but it wasn't scheduled in advance. I didn't want to schedule it until I knew for sure that nobody'd have a problem. But but this is the brief, and let me. I got to make it bigger so you guys can read it. So let me.
Hey, Glenn, just a quick question. Would you be willing to share this brief so we can read? Or no?
I can upload it. Is that what you want?
Yeah, please, thank you.
Okay. Let me just. Actually, I've see, where is it? I think I've got it ready to file, or I already filed it. No, I haven't filed it yet. But this is actually, I'll upload the Word files because then you'll have so I'll do that to the group. Let me find my page.
So does it talk about and define that there is no such thing as a license to practice law?
No, I don't go into that. Okay, so it's uploading right now.
Thank you.
Looks like we got some viewers already on YouTube. Okay, so this is just the brief because I haven't printed it yet because I don't know what the end one is going to be all about until I get their motion. And so and you can see it half decent in the live stream. Good. So they did a motion to dismiss, and I'm just making a wag about what they're gonna say, and so I've already told them that they don't have immunity. So maybe they'll bring that up again, and I don't address that in this brief. But so comes now the demandants requiring this court to deny the State Bar of Texas motion to dismiss. And number one, there's an emerging bar member dictatorship in Texas because they assault you with the Commerce Clause, Article 1, Section 8, Clause 3, with plenary power of Congress, which is plenary power is a court's full and absolute power of a subject matter. Plenary power is complete power of a particular area with no limitations. It's a dictatorship, which means no common law rights, and there's no common law offenses against the United States. Only those acts which Congress has forbidden are for disobedience of its command or crimes, and that's in violation of Article 1, Section 8, Clause 17. And if you object to it, they refuse to do anything. The demandant filed bar grievances against the State Bar of Texas, regulated by the Supreme Court, with the State Bar of Texas, which is regulated by the Supreme Court of Texas, against 95 different bar members, some more than once. And they're all dismissed as an inquiry. And the demandant filed dozens of judicial complaints with the State Commission on Judicial Conduct. The judge's educational curriculum is determined by the Supreme Court of Texas, and they're all dismissed, 25 on the same day. The State Commission on Judicial Conduct consists of 13 members, the majority of bar members, 5 appointed by the Supreme Court of Texas, 2 appointed by the State Bar of Texas. The defendant filed hindering prosecution felony charges against every member of the Supreme Court of Texas in an effort to make them aware of what was happening. And they refused to do anything about it. Anyways, so the common law requirement. First of all, the Constitution of the United States, dated September 17, 1787, which is still in effect and has never been declared void, and is the oldest written Constitution still in effect today, wherein in Article 1, Section 1 states all legislative powers, herein granted shall be vested in the Congress of the United States, which shall consist of a Senate and House of Representatives. In Section 8, Clause 9, that's Article 1, Section 8, Clause 9, it states that the Congress shall have power to constitute tribunals inferior to the Supreme Court. The Constitution had not, prior to the statement in the Constitution being written, since this was Article 1, provided for a legislative Supreme Court. They were and could not, without any doubt, be referring to our one Supreme Court in and of the common law, which was already established and active in America and the United States of America. It's clear that the Constitution is now setting up another set of courts called legislative courts, and they refer to them as inferior courts, meaning inferior to the already existing common law courts. Our one Supreme Court, Article 1 of the Constitution, did then and there set up legislative courts inferior to common law courts, as verified by Article 7 of Amendment to the Constitution, wherein it guarantees that in suits of common law, no fact tried by a jury shall otherwise be re-examined in any court of the United States than according to the rules of common law. The Supreme Court, talked about in Article 3, establishes a legislative inferior Supreme Court of the United States for the District of Columbia, which is established by an act to establish the judicial courts of the United States, approved September 24, 1789. But the only true Article 3 court for we the people is our one Supreme Court, a common law court of the people, by the people, and for the people, and was in existence prior to the Constitution. And this is Hale versus Henkel. His rights are such as existed by the law of the land long antecedent to the organization of the state. And so antecedent means before. So law of the land is an interchangeable phrase with common law. Law of the land and common law both mean the same thing. This sets the courts of common law separate and apart from legislative courts, such as this court or the 97th District Court, otherwise being a maritime court, in that any case tried in this court or the 97th District Court can be re-examined by action of appeal. This places this court and the 97th District Court as one of the inferior courts referred to in Article 1, Section 8 of the Constitution of the United States. Note the difference in a trial by jury in common law as to a trial with the jury in legislative inferior courts. The judge in the inferior court instructs the jury on what they will hear and decide upon and what they will not. There is no such provision in common law. A common law trial by jury means the jury conducts the trial. It is self-executing and needs no legislative implementation to regulate its process or confer jurisdiction. The Northwest Ordinance of 13 July 1787, less than 3 months prior to the Constitution, which had never been altered by common consent or in any way or manner, presently remains in force. The last words of the introduction or preamble of the Articles of Ordinances, Section 14, state, "The following articles shall be considered as articles of compact between the original states and the people, and the states in said territory, and shall forever remain unalterable, and was intended to be a part of the Articles of Confederation, and forever unalterable. And all previous engagements entered into," quote, "all debts contracted and engagements entered into before the adoption of the Constitution shall be as valid against the United States under this Constitution as under the Confederation." That's Article 6, Clause 1 of the Constitution. It includes the Northwest Ordinance, which is in full force and effect in Texas. And in fact, what you got to think is that the Northwest Ordinance defines the nature of federal jurisdiction in federal territory. And so anywhere the federal government has authority, like in, for example, federal enclaves, etc., or federal territories, is defined by the Northwest Ordinance. The Compact Agreement is a federal injunction, defines the nature of federal jurisdiction in federal territory, and is forever unalterable, either by legislative Congress or its legislative Supreme Court or its other inferior courts or the administration. It is protected by Article 6, Section 2, Clause 1 of this Constitution for the United States of America, which guarantees, no, that's Article 4, Section 2, Clause 1, which guarantees the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Article 2 of the Compact Agreement states, the inhabitants of said territory shall always be entitled to the writ of habeas corpus and of trial by jury and of judicial proceedings according to the course of the common law. Legislative law, statutory law, is in fact an extension of maritime law. In 1946, the 1946 Administrative Procedures Act, Title V, United States Code, Section 559 at Sentence 2, requires the administrative law to be in compliance with and in conformity with the Constitution for the United States of America, and the common law with all its prohibitions, restrictions, restraints, and limitations imposed by its enumerated bounds and boundaries as described in the first 10 amendments. And history is clear that the first 10 amendments to the Constitution were adopted to secure certain common law rights of the people against invasion by the federal government. The Maritime Code, otherwise known as statutory law, being administered in legislative inferior courts, this court and the 97th District Court, as evidenced by the Maritime Gold Braid Flag or the corporate seal in the courtroom, also acknowledges that when brought inland, beyond the high water mark or the first bridge of any navigable river, they must be brought into compliance with and in conformity to this Constitution for the United States of America and subject to the common law. And this is 1 Stat 77, which is the Judiciary Act, the original that created that act created the Supreme Court and all the legislative courts, the federal courts. Anyways, saving to suitors in all cases the right to a common law remedy where the common law is competent to give it. And then in the judicial code in like the 30s, when this was passed, third, in all causes of admiralty and maritime jurisdiction, saving to suitors in all cases right of a common law remedy where the common law is competent to give it. Thus, meaning competent, common law is not extending in reverse to the high water mark and extending to the sea or the jurisdiction of maritime law or to exercise jurisdiction as stated in the Constitution under Article 1, Section 8, Clause 17 and 18, wherein it declares that the inferior tribunal shall exercise exclusive legislation as prescribed by Congress. And then 17 and 18, this is right from 17 and 18. Over such district not exceeding 10 miles square as may by session of particular states in the acceptance of Congress become the seat of government of the United States and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of ports, magazines, arsenals, dockyards, and other needful buildings. To make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution and the government of the United States or any other department or officer thereof. So let's see here. Wow, the image coming through on YouTube sure doesn't look too good. And there's some comments in YouTube, so I'm just looking at them right now. I'm not sure why it's coming through like that. That's weird. It says there's an excellent connection. Maybe they don't want the stuff coming through. Yeah, I wouldn't be surprised. Anyways, so it looks like there's 22 people viewing right now. Yeah, Title 26 is not positive law. So anyways, okay, so let's keep moving here. So therefore, all legislative courts have jurisdiction in the District of Columbia only under the Commerce Clause, which is why they use zip codes, which are only in the District of Columbia, and commercial papers / Federal Reserve notes / forced loans, which are only for use in the District of Columbia, and 12 Stat USC Section 411 and the Gold Reserve Act of 1934 at 48 Stat 344. Legislative statutory inferior courts themselves admit the validity of the common law court in Strauss versus Strauss, 1941, which states every system of law known to civilized society generated from or had as its components one of three well-known systems of ethics: pagan, Stoic, or Christian. The common law draws subsistence from the latter. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It is the guide by which we dissolve domestic frictions and the rule by which all legal controversies are settled. Whereas we learned that the law of the land means the common law. State versus Simmons, Spears, 2 Spears, 761, 1884, Justice O'Neill speaking for the court, Taylor versus Porter, 4 Hill 140 at 146, Webster's definition of the law of the land, at Dartmouth 4 Wheaton, 518 at 581 and 582, which is affirmed by Article 6, Clause 2, which declares this Constitution shall be the supreme law of the land. In Wiley versus Commons, 1851, acknowledges the common law in the Holy Bible from which it came, which it is the foundation of the common law, is our God-given constitutionally secured right. The 97th Congress declared the Holy Bible to be the Word of God by joint resolution, Public Law 97-280, 96 Stat 1211. This legislative inferior court fails to be an Article 3 court, and this is Balzac versus People of Puerto Rico. The United States District Court is not a true United States court established under Article 3 to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3 of making all needful rules and regulations respecting the territory belonging to the United States. This court is required to provide the demandant a Republican form of government, Article 4, Section 4 of the Constitution, and as one of we the people, the demandant is a state in this union because we the people are the state, and have immunity against County of Montague in Article 11 and Amendment, under Article 11 and Amendment, and their bar members. The government is but an agency of the state being the sovereign people, State versus Chase. A state does not owe its origin to the government of the United States in the highest or any of its branches. It was in existence before it. It derives its authority from the same pure and sacred source as itself, the voluntary and deliberate choice of the people. So we the people are the state. And a Republican form of government fails to include the District of Columbia Commerce Clause under Article 1, Section 8, Clause 3 because of Article 1, Section 8, Clause 17. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square. All County of Montague and their bar members are engaged in the theft of the demandant's land with their forced rendition, and the bar members are the most responsible. And this is Hale versus Henkel. The individual may stand upon his constitutional rights as a citizen. His rights are such as existed by the law of the land long antecedent to the organization of the state, long before. I quoted that one before, actually. The individual, unlike the corporation, cannot be taxed for the mere privilege of existing. The corporation is an artificial entity which owes its existence and charter powers to the state, but the individual's rights to live and own property are natural rights, for the enjoyment of which an excise cannot be imposed. And their inferior legislative maritime court failed to be a trial by jury and absolutely failed to have anything to do with common law in violation of 1 Stat 77, Section 9A, and 36 Stat 1611, Section 256, Part 3. And it was an administrative hearing that failed to have an Article 3 judge, but was an executive branch administrator, which means any decision was a bill of pains and penalties, which is similar to a bill of attainder and prohibited, because inferior legislative courts are an extension of the legislature, and there is no Article 3 judge present. Therefore, it's a non-judicial legislative act targeted at landowners, which means it's a bill of pains and penalties. No separation of powers. In 1861, Lincoln ordered Congress to reconvene under executive authority, 15th of April, 1861 at 12 Stat 1258. And 3 months later, on August 5th, 1861 at 12 Stat 292, while operating under executive authority, Congress approved an act to provide for increased revenue from imports and pay interest on the public debt and for other purposes, which precipitated all of this. And Congress is operating under executive authority ever since. In 1871, under executive authority, Congress created a municipal corporation called United States for the government of the District of Columbia at 16 Stat 419 under Roman law. And now there are two national governments, one of which Congress operates outside and independently of the Constitution for U.S. citizens and resident aliens under the Commerce Clause. And Downs versus Bidwell, 1901, two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. The Supreme Court ruled on a case that Lincoln failed to like, and Lincoln sent troops to the Supreme Court, which resulted in Rule 45. Process mandates. 1. All process of this court issues in the name of the President of the United States. Therefore, there is no separation of powers, and everything is under authority of Congress operating under executive authority. And this legislative inferior court is actually the executive branch operating under Roman law. And all officers of this legislative inferior court are executive branch administrators with no common law. But there are no common law offenses against the United States. We already read that one. The state of Texas is a municipal corporation operating under executive authority that's a subsidiary of the United States corporation domiciled in the District of Columbia, operating under the Commerce Clause executive authority with no common law. Under Texas law, no act or omission is a crime unless made so by statute. The legislature may create an offense and in the same enactment provide exceptions to its application. Congress approved the Code of Law for the District of Columbia at 31 Stat 1189, March 3rd, 1901, which is now known as the United States Code, and all courts, federal and state, operate under. Posterity. This legislative inferior court is operating under the demandant's authority because Will Livingston, who ratified this Constitution for the United States of America on behalf of New Jersey, 18 December 1787, is the demandant's fourth great uncle, which means the demandant is posterity as found in preamble, and the demandant's entitled to right of blood. And no civil law can destroy right of blood because all the laws of Congress and all the laws of Texas are civil laws. And this is a maxim of law right here. Bouvier's Law Dictionary, the right of blood and kindred cannot be destroyed by any civil law. Bouvier's Law Dictionary, 1856 edition, page 768. And this court is operating under power which is derived from the demandant as posterity, and the maxim says the power which is derived cannot be greater than that from which it is derived. And that's Bouvier's Law Dictionary, 1856 edition. Therefore, it's impossible for the demandant to give any of these wrongdoers or their bar member handlers or this court any authority over the demandant, and the Supreme Court of the United States agreed and said it was impossible for the demandant to confer a sovereignty which will extend over him. And this is McCullough versus Maryland. The sovereignty of a state extends to everything which exists by its own authority or its permission, but does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given by people of a single state. They are given by the people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer a sovereignty which will extend over them. And that's McCullough versus Maryland. That's like early 1800s. 1819, I think, or something like that. Anyways, and the demandant is exempt from the county of Montague or their bar member handlers, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And that's Cowanecoa versus Polyblank, U.S. Supreme Court, 1907. And the demandant requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States, which is the supreme law of the land, anything in the constitutional laws of any state to the contrary notwithstanding. And that's Article 6, Clause 2. Bar is Vatican, which is the 1781 corporation owned and operated by the Vatican, or the 1871 corporation, I should say, owned and operated by the Vatican. It appears that the bar changed in 1947 because the bar treaty of 1947, which is supposed to be effective in the District of Columbia only. BAR is an acronym which stands for British Accredited Regency, because all bar members are appointed under authority of the Inns of Court, and this is Inns of Court. They are certain private unincorporated associations in the nature of collegiate houses located in London, which and invested with the exclusive privilege of calling men to the bar. And that's Black's Law Dictionary, 5th edition, page 709, which is one of 4 law schools located in the city of London, which is owned and operated by the Vatican from the concessions of the Pope, 1213. We will establish a perpetual obligation and concession. We will establish from the proper and special revenues of our aforesaid kingdom for all the service and customs which we ought to render for them, saving in all things the penny of St. Peter. The Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael's 500 marks and Easter 500 marks, 700 namely for the Kingdom of England and 300 for the Kingdom of Ireland. And that's concessions of England to the Pope, 1213. And the concessions to the Pope, 1213, precipitated the Magna Carta, 1215, because King John was trying to collect revenue to pay the Vatican, as evidenced by Chapter 29, which put a stop to their non-judicial proceedings. No freeman shall be taken or imprisoned or seized or outlawed or exiled in any way destroyed. Now shall we go upon him or send upon him, but by the lawful judgment of his peers or by the law of the land. And several chapters of the Magna Carta where they were prohibited from charging certain fees. And all bar members are here as regents, British Accredited Regency, a regent, the office or jurisdiction of a regent or body of regents. Regent, a person who exercises ruling power in a kingdom during the minority, absent, or other disability of the sovereign. We, the people, are asleep at the wheel. Black's Law Dictionary, 8th edition, page 4010. Because the municipal corporation set up in 1871 called United States went bankrupt in 1933. It's an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt, being bankrupt and insolvent. HJR 192, 73rd Congress in session, June 5, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all United States governmental offices, officers, and departments, and is further evidence that the United States federal government exists today in name only. The United States Congressional Record, March 17, 1993, volume 33. And is owned and operated by the Vatican. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. And that's a quote from Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, May 5, 1903. As evidenced by the Roman Achaea military staff, carried in battle by all Roman commands and planted on all conquered nations, that's sitting on the right side of the speaker's podium in the House of Representatives, and 2 Roman fascia on the wall on each side of the speaker's podium. Therefore, all bar members are foreign agents of the Roman cult here to impose the martial law rule for the Vatican. And this is ex parte Milligan. There are 3 kinds of martial law. Full martial law, declaration of martial law is issued, troops put on the street, used only during wartime, used on a foreign country when actually invaded by a foreign power or to put down an armed rebellion. Martial law proper, law of the armed forces, when a captain tells a private what to do, enforced by court-martial. And martial law rule, the law of necessity and emergency, allows the domestic use of martial law powers as used during times of peace. and in the District of Columbia only under the Commerce Clause, which continues to this day. Since March 9th, 1933, and notice that that's the same date that right up here, established fact, the United States federal government's been dissolved by the Emergency Banking Act, March 9th, 1933, same day. Since March 9th, 1933, the United States has been in a state of declared national emergency. Under powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel in a plethora of particular ways, control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And that's U.S. Senate Report number 93-549, dated November 19th, 1973. Do you think anything has changed? Actually, it might be starting to change under Trump, but we'll see. And anyone who hires an attorney is an imbecile. Clients are called wards of the court. That's Book 7 of Corpus Juris Secundum, Section 4, Attorneys. A ward of the court, infants and persons of unsound mind, their rights to be guarded jealously. Yeah, right. And that's Black's Law Dictionary, 4th edition, page 1755. Which is why the bought and paid for clerk Byers in the 97th District Court was operating a star chamber with a forced bar member because she intended to presume jurisdiction. In propria persona and one's own proper person, it's a ruling and pleading that pleas to the jurisdiction of the court must be pled in propria persona, because if pleaded by attorney, they admit the jurisdiction as our attorney is an officer of the court. He's presumed to plead after having obtained leave, which admits the jurisdiction. And the defendant's ancestors attempted to prohibit these foreign agents of the Vatican from holding any office of trust requires an oath of office, as found in the original Article 13 and Amendment, taken from a certified copy of the 1819 Virginia Statutes. If any citizen of the United States shall accept, claim, receive any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present, excuse me, any, just a second, I got to take a drink. Any present pension, office or emolument of any kind, whatever, from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. And it seems to have disappeared around the Civil War time period, and it has come out that the Vatican was involved in recent election interference. Quasi-contracts. Let's see what's happening. Oh, the live stream is looking better, that's for sure, and there's a lot of comments. So this is what we're talking about on We Are Law. I've uploaded videos about We Are Law, but this time we're doing a live stream, so I won't need the videos. Well, being a state national, it's actually, you need to show that you're, or claim that you're a state and you have immunity under the 11th Amendment, and you got to be able to defend it. Title 26 is a fraud. Yes, we know it's a fraud. It's not positive law, first of all. Positive law, like Title 42, 42 is not positive law either. Title 18 is positive law. How do we enforce it? That's right. I mean, it's what we got to do. That's why I'm suing them. And so that's what you got to do. I'm bringing this as a collateral attack. So we'll see. This is over property taxes. Anyways, okay. So let's keep moving. Quasi-contracts. All Texas codes are constitutionally prohibited bills of pains and penalties, as in Texas Penal Code penalties, Penal Code, because they assault you with a quasi-contract using their District of Columbia Municipal Corporation and Roman law. Assumpsit. In its origin and action tort, assumpsit was soon transformed into an action of contract, becoming afterwards a remedy where there was neither tort nor contract, based at first only upon an express promise. It was afterwards supported upon an implied promise and even upon a fictitious promise. Introduced as a special manifestation of the action in the case, it soon acquired the dignity of a distinct form of action which superseded debt. Now look at these, are commercial words, okay? Look at all these commercial words here. Superseded debt, became concurrent with account, with case upon a bailment, a warranty, and bills of exchange. And competed with equity in the case of essentially equitable quasi-contracts. Well, see, all these courts are martial law courts, they're courts of equity. Both in Roman and English law, there were certain obligations which were not in truth contractual, but which the law treats as if they were. They were contractual in law, but not in fact, being the subject matter of the fictitious expansion of the sphere of contract to cover obligations which do not in reality fall within it, which requires the minor estate at 31 CFR 363.6, U.S. citizen or other fiction. Quasi-constructive quasi-contracts are based solely upon the legal fiction or fiction of law. So they consult you with the quasi-contract for their penal action. The words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeiture to be forfeited for non-compliance with an agreement. The words forfeit and penalty are substantially synonymous. A penal action is a civil suit, but they call it quasi-criminal is what they'll call it if you pin them down. The penal action is a civil suit brought for the recovery of a statutory forfeiture when inflicted as punishment for an offense against the public. Such actions are civil actions, on the one hand closely related to criminal prosecutions, and on the other to actions for private injuries in which the party aggrieved may by statute recover punitive damages. A penal action is one founded entirely upon statute, brought with the sole object of recovering a penalty or forfeiture imposed as punishment for a specific offense, while a remedial action one brought to obtain compensation or indemnity. Which is why they use Roman law of capitis diminutio. Capitis diminutio maxima, meaning a maximum loss of status through the use of capitalization. The highest and most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. It swept away all rights of citizenship and family rights. Because capitis diminutio maxima is used when they enslave you, and they are Satanists using fraud and deception to sell you into slavery as collateral for their minor estate, at 31 CFR 363.6. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state. Which are non-judicial proceedings, because whenever a statute's involved, the judge is actually a bought and paid for clerk masquerading as a judge. It's the accepted rule, not in the state courts, but at the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial clerk for the agency. Judges would be involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency. Which is why it's a bill of pains and penalties and unconstitutional, because they have no authority to do anything judicial. Ministerial officers are incompetent to receive grants of judicial power from the legislature, and their acts in attempting to exercise such powers are necessarily nullities. But the reality is the bar members do it all the time. The prisons in Texas are populated by quasi-contracts, and the bar members did it in this case. The War of Independence was fought over taxation without representation, and now these District of Columbia bar members use the Commerce Clause to bring the District of Columbia outside a maximum of 10 miles square. And this is National Mutual Insurance Company of District of Columbia versus Tidewater Transfer Company. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia through their plenary power nationally. Remember, we talked about plenary, it's dictatorship. Through their plenary power nationally covers those citizens even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. in violation of Article 1, Section 8, Clause 17, to represent the demandant by force and make legal determinations for the demandant that the demandant's a minor estate, is an imbecile, is a taxpayer, is their slave, so they can tax the demandant. If it were true that according to the spirit of our Constitution, the power of taxation must be limited by the right of representation, whence is derived the right to lay and collect duties, imposts, and excises within this district, if the principles of liberty and our Constitution forbid the raising of revenue from those who are not represented. Do not these principles forbid the raising by duties, imposts, excise, as well as by direct tax? And that's Longborough versus Blake, U.S. Supreme Court. And use it as justification for the theft of the demandant's land. So I had to keep this under 10 pages, and if you look here, there's page 10, the bottom of page 10. And so I've been scrunching it down big time. Anyways.
That's a record for you.
What's that?
That's a record for you. That's a record for you.
Why you say that? Keeping it under 10 pages?
Yeah.
No, I keep them all under 10 pages because see what happens under their local rules, if I go more than 10 pages, then I have to have a table of contents and a list of authorities. And that's a whole bunch of stuff that is more stuff that I want to have to mess with. And so I just kept it under 10 pages. So anyways, that's a lot easier just to keep it under 10 pages. I have to scrunch it in. So anyways, so that's all that one is. Does anybody, let me go and look on YouTube and see if there's questions on YouTube. And meanwhile, you guys can be thinking about questions too.
There's smart people on here that are questioning the courts right now, whether or not they want them to define whether or not us as sovereign citizens can even own land.
Well, of course we can, but it's whether they can say anything to us. And according to McCullough versus Maryland, they can't. Remember, I read that case, McCullough versus Maryland. That's why they have to use the Commerce Clause. Even that is, they can't even use the Commerce Clause, quite frankly. But McCullough versus Maryland right here. Right here.
Well, no more tenants.
Sorry?
No property taxes, nothing like that. We own it outright. We own property.
That's right, as long as you don't have a loan on it or something, but it's the sovereignty of a state extends to everything which exists by its own authority, is introduced by its permission. But if you are, or even claim.
We're about the property tax.
Well, this case is about property taxes. This is in Texas, though, so
Okay.
every state's going to be a little bit different. But yeah, this case is about property taxes. But consequently, the people of a single state cannot confer sovereignty which will extend over them. And then there's another case that basically says the same thing, this Kawanakoa versus Polyoke. A polyblank, and not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And so, again, they have no authority. And there's other cases where it says that the rights of the people cannot be impaired by legislation or judicial decision. And so if you notice, I tell them this is what I require. I'm basically telling you this is what you have to do. You know what I mean? Quasi-contracts.
Yeah. Right.
Requirement.
You went so fast there. Can we, maybe you can put those in the chat for me. Yeah, thanks so much, Glenn. Because this is a big question, right? This is what it all boils down to.
I uploaded the files to my page on Telegram. This is We Are Law for YouTube. This is We Are Law on Telegram. So we do this every Friday night around 9 o'clock Central Time, 10 o'clock Eastern. And so on YouTube, you can go into Telegram and see this too. But we're going to try and upload these to YouTube too. So anyways, for what that's worth.
Okay, thanks, Glenn.
Thank
Sorry?
you for that.
Yeah, no problem. Let me. They're asking for a link. So let me see if I can get a link.
I can go in your channel here on Telegram. That's just fine. I'm right here anyway.
Well, no, they're asking for a link on YouTube to the Telegram channel.
Oh, yeah, okay.
Yeah, they're asking for a link, but I'm looking. I don't see a place where there's a link.
I can get that for you, Glenn. It's kind of like a Telegram link, though.
Yeah, it would be. Yeah, but that's okay. They send it to YouTube and they click on it. It'll take them there.
Okay.
Maybe sometime we can talk or discuss later, or any time next week or something on the combining the equitable and legal titles and your thoughts on that. Whenever.
Well, equitable is all martial law, and so and legal, that's some sort of contract. I don't. I try and stay away from any of that stuff. I basically tell them this is the way it is. I'm the king, and these are my instructions, and this is what I tell the judge. And so far, he's done everything I wanted him to do.
Yeah.
So
yeah, I'll look at those case laws and stuff. Because I'm interested in the owning property, right?
Well, there's
So
three
we'll see.
things. There's three things you need if you want to be truly sovereign. You have to have people, land, and resources. In other words, gold or silver coin. And land is land, and people is you. And so you got to have to be a nation. That's what you have to have. And so, the Constitution was set up so that we're all, sovereign nations.
Right. Just getting them to follow the de jure is pretty hard.
Well, it's they're confused. A lot of it is our own fault or the fault of many of our clueless countrymen that don't have a clue about how the law works. But I've had judges that sent me an order to file a lawsuit, and I've had that happen, and in fact I got to file that lawsuit that they sent me an order to file a lawsuit. And so that's on my bucket list, with all the rest of the shit that's going on. But I think now is a great time to file, stuff like this because of the Department of Justice is changing, and so this is a great opportunity. Yes, in the YouTube chat they talk about Ron Gibson. Yes, Ron Gibson is the guru when it comes to land patents. But
I was just gonna mention Ron.
Yeah,
him and Boris were at a Zoom I was in with him and Boris Eckerson. You're right, and it got pretty ruffled.
Yeah,
yeah.
I don't know. I know Boris, but I haven't.
You did.
Sorry.
I figured you did if you knew Ron. I figured you knew Boris. He's been around a long time.
Yeah, I don't know Ron. I know of him, but that's it. But Boris, I know. I mean, he calls me up sometimes.
Right.
But Ron, I haven't met him. I know of him. I've seen his material. I think he's brilliant. And I know that with my stuff, a lot of it depends on how corrupt they are, because I know that, I don't do a title search. He says you have to do a title search, and I agree, you have to. But I think a lot of it depends on how corrupt they are, and if you're prepared to defend it. And so, like, I don't do title search. That's a huge job. I've done title searches, but it's a huge job. So I did that once, and then when I saw how much work it was, I wound up having to spend 3 days at the county recorder's office. And, it's a huge job. You're digging through all those records and stuff. And so I don't do title searches. But and again, a lot of it depends on how corrupt they are. I brought forward the land patents, and it depends on the state. Arizona is probably one of the best. I think that Arizona is, they actually try and do it right, like they have an affidavit of property value, and so when you buy land, you're supposed to fill out this affidavit. So, what I do is I pay cash for it. And then I send them the deed, and on the deed I say that gold or silver coin was used to. It's actually with Ron. He says you have to do a bill of conveyance, and that makes a huge amount of sense. Until I saw some of Ron's stuff, I didn't know about the bill of conveyance, and I called it a bill of exchange, which it is. You're converting silver to gold, or silver to land. And I've seen court cases that talk about it where they converted silver to land. And that's what I do. When I buy land, I convert silver to land. Anyways, so, but you're supposed to call it a bill of exchange. And I think that's brilliant. And I think that's exactly 100%. And I haven't transferred land since I learned about that. But next time I do, that's the way it's going to be. So,
right. Very good.
Yeah. Yeah.
So if somebody can put a lien on that property, we don't, I mean, somebody can try, but there shouldn't be any liens to be able to put on it, to have and to hold, right? Unencumbered, right?
If you read that act of Congress in 1820, where they talked about they wanted an unembarrassed freeman. And they wanted land that was unencumberable. And so, and I've actually I've brought forward land patents for people. I did it for a friend of mine here in Texas, and he died, and his family didn't understand it and weren't interested in defending it. And so it wound up getting sold at a tax sale. And the neighbor bought it, and the neighbor happened to be the mayor of the town, and a friend of mine knows the mayor. And they were talking one day, and the mayor told him that he couldn't get bank financing because of the land patent. And that's exactly right, because no equitable interest can prevail against the land patent. And so they couldn't get bank financing. And so he had to get a friend to loan him the money. And so, anyways, it's I'll tell you, they work. They're not going to let on that they work. There's another friend of mine. There's a lady I met here in Texas that said that she'd been out of work. She was in a house that she didn't even bring forward a land patent. She didn't understand about that, but she was in this house 10 years after a foreclosure, and she was still in the house. And so she had been out of work. This was an expensive area. She couldn't afford the $10,000 a year in property taxes. And so she went down and read the riot act to them. Who rented this property for taxation? I'm going to sue their butt off. And they immediately came back and said, don't worry, we'll take it off the tax rolls. So yeah.
Alcohol, tobacco, firearms. Hello.
Yeah, so
if it's alcohol, tobacco, and firearms, now what?
Yeah.
Yeah, where's the property? Oh, give me the original bill, Show me the original bill. Right? Show me the original.
Well, I don't even go there. I mean, you're talking commercial terms now, and I don't go into commerce, period. And you have a right to own property, own land. Those statutes in Texas, the land that they tax is commercial land, is land that's owned by corporations. And you read their acts, it's always corporations that own it. And what they're doing is they're assaulting you with that minor estate. And actually, in this case here, that in the actual lawsuit that I filed, I'm telling them that I'm suing that minor estate too, that 31 CFR 363.6. Mm-hmm. I'm suing that minor estate and Janet Yellen. Mm-hmm. I want it dissolved and liquidated. And I want it dissolved and liquidated yesterday, not today, yesterday.
Mm-hmm. Well, that's kind of commerce stuff. I have a question for you. So during emergency or wartime, which we are still under, basically martial law, we're still under war, right? It's never been lifted to martial law. So I'm going to suggest that this owning if they want to come on and utilize my land and property, they do. Am I wrong? So if I own property, they shouldn't be able to come on it.
Well,
This is a very fine line we're talking
actually,
here, aren't we?
Actually, warfare is subjects of the enemy. Okay, and the only thing that's subject to the warfare is subjects of the enemy. And so, if you're the enemy or a subject of the enemy, then yeah, you're engaged in warfare. But we, the people, the warfare doesn't affect we, the people, and that's actually treason. That's a breach of trust for them to try and impose the warfare on us. That's why it's so powerful to say that your posterity, that like in my case, I can say that Will Livingston's my fourth great uncle, and that's when I brought that up. That's when everything changed. That's when they sent me orders to file a lawsuit and that kind of stuff. And so with this judge that I'm dealing with, I tell him the stuff that I told him in here, that he's an inferior court, but he's supposed to give me a Republican form of government, and that if you read that National Mutual Insurance Company case, let me pull that one up again, because it says right in there that actually I don't have that. Yeah, I don't have that part in here. Actually, it says, let me find it. I'll find it because it's pretty interesting. There we go. Yeah, let me share this one. Share a different one. Oh, here we go.
I'm with you. I definitely agree. We can own property, but there's sure not making it easy for us.
Well, again, yeah, you're right. Well, they're a bunch of pirates. I think it's all going to change here with Trump, though.
Well, if you want to be prosperous king, you want your people prosperous too. You're not a prosperous king unless the people that are too. But once again, we're still under the corporation. But we can work together. We can work together, I think.
Here it is. This says this is the first part of that case. National Mutual Insurance Company says, we therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within the Article 3 of the Constitution. In other words, citizens between citizens of the district and those of the states are not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. So if you're suing, like I'm suing some U.S. citizens, and so I don't get an Article 3 court, but I don't really care. I'm telling them, you don't have any authority over me anyways, and you're supposed to regulate your property, so get off your ass and regulate your property. That's what I'm telling them.
Yeah. All right. Yeah. Got to keep moving forward. Good.
So anyways, we'll see what happens.
Thank you.
I'm expecting to get, see, I'll make that bigger so it's easier to read. There's actually a lot of court cases that talk about this. It's not, there's a lot of court cases. This is all a Commerce Clause, and if you're in the Commerce Clause, there's no common law, and it's a dictatorship, and so you don't want to be there, and
yeah.
So
there's ministers. They have a purpose, though.
They can regulate it. I don't have a problem with them regulating it, but I don't want to be in the Commerce Clause. Now that doesn't mean you can't buy and sell and you can't do business with people. I mean, commerce has a very specific definition, the commerce that they're talking about. And so that doesn't mean, like, I can still, get compensation for my labor. I can still and not be in commerce. And I can, a friend of mine has cell phones and he buys and sells cell phones all day. He's not involved in commerce. Okay. He doesn't have to be involved in commerce to do that. And so commerce has a very specific definition, and what gets you into the commerce, one of the biggest things is the Federal Reserve notes. There's people I know that do that stuff. There's people I know that have game rooms, and they have a big sign out front saying no Federal Reserve notes allowed, and they only use silver coin in that game room, and the cops leave them alone. They leave them alone. And game rooms are illegal in Texas, but they have one, and the cops don't mess with them. And so,
that we can all make a private, lodge, right? They serve alcohol and on these places too, and don't get their license. Yeah, I see where you're going with that. Yeah.
So if you stay away from the biggest thing is Federal Reserve notes and commercial paper. But there's other things that are required to get you into commerce, or international commerce. If you're buying something from a foreign state, well, then you're that could be commercial, and so or overseas. But even a private man like me, I can order something on eBay from overseas, and I'm not involved in commerce. Now, they can be involved in commerce, but I'm not. I'm just a private man. I'm buying something. And so I'm not involved in commerce. They can be. And so they have the requirements. I'm not buying it to keep an inventory. I'm buying it to use it. You know what I mean? If I was buying a large amount, then they could consider that commercial. But because I was going to sell it, turn it around and sell it, but it'd have to be a very large amount. But so anyways, you have to understand that. Some people think that just because you're going and buying some milk at the grocery store that you're involved in commerce. No, that's not true. And you can't, you don't have to do that.
Well, I'm not too worried about it either way. I'm going to learn both sides of the equation. So, I'm going to do what I do. Render unto Caesar what is Caesar's, unto God what is God's. I can do both, and people, get fearful of that. But I'm going to learn. I'm going to learn it all.
Well,
yeah,
it's a journey.
I need to know when and where and what venue I'm in, for instance, so, I know what hat to wear. When I learn that, then, when a man or woman learns how to do that, well, it's all good. It's all good, I think.
Yeah, I try and stay away from commerce. You have to be careful about that because there's no common law there. And so that's why, like when I filed this lawsuit, I went and actually paid the filing fee, and I filed a notice of objection to the extortion racket. And I told them that they're not authorized to, that I'm not a U.S. citizen, and they're not authorized to tax me, and I'm immune and under the 11th Amendment, and they can't convert a right into a privilege. And so the point being is that once I file that notice of objection, they can't use it against me. And so it's the same thing as if you object. Then, and I put on the money order. I wrote on the money order when I made it out to the court. I wrote on the bottom under the comments. I wrote extortion, and I told them I wanted a copy of it, and so they were glad to give me a copy. And so I attached it to the notice of objection, and so they can't use it against me. And so and then they sent me a notice that I had like 10 days to set up electronic filing. And I said, I responded to to the electronic filing requirement. I said, sure, no problem. I'll set up the electronic filing. When you send me your statutory and delegated authority that requires me to get a social security number and requires me to get a driver's license and requires me to get a bank account, and then I need a Fourth Amendment warrant that shows that I'm required to disclose all that information. And it was crickets. And now the judge, every time there's a motion, he sends me an order saying that I got before me this motion, and so you got until this time to respond, or there might be an answer to the motion without your response. And so he's babysitting me is what he's doing, and that's good. I like that.
Sure. Are you attorney in fact?
No, I don't bring that up. They're calling me pro se, and I just tell them I'm a man. I'm a man,
There you
and
go.
and
Yeah.
if I'm anything, I'm pro per. I tell them I'm pro per, not pro se, and
There we
so
go.
yeah, I and that's what I'm doing, and so
There you go.
they
Yeah.
and I think they respect that. The first time I did this, I filed a lawsuit against FedEx one time, and FedEx removed it into federal court, and I didn't want it in federal court. I figured they'd dismiss it, and so I told them, but I never went into court and told them this, but I sent paperwork in, and I said, I have nothing but contempt for you and your so-called court. You have an inferior court of limited jurisdiction, and everything you do is brutum fulmen. And brutum fulmen means Latin for an order is an empty noise. Anyways, and after that, he was so nice to me, I couldn't believe it. I felt guilty after that.
Yeah, good for
So
you.
so
Yeah.
they respect it. They respect it when you tell them the way it is, and especially if you're right. If you're right, then they respect that. It's when you go there and start begging that they just walk all over you like you're a piece of crap. You know what I mean? And so I've had nothing but respect from the judge, and that's good. That's appreciated, and he babysits me a little bit. And that's good. I don't mind that either. I don't want to. I want to help him to help me. You know what I mean? And so
Yes, I do.
he's got to maintain impartiality and all that stuff. But I think I'm kicking their butt. They filed so many motions to dismiss, and I turn around and file a motion to strike. Well, a lot of them I filed a motion to strike because the Attorney General is representing people like these judges, and I sued these judges in their private capacity, and I filed a motion to strike. As a matter of fact, what I did is the U.S. attorney appeared and called me a sovereign citizen, and I went and I said, I am so sad and disappointed that she went and said that. I said, first of all, Congress in 1940 said that all Americans are sovereign citizens, and number one. And I said, number two, the Supreme Court in 1873 said everyone and everything not privileged is sovereign. And I said, so how come she's not sovereign? Oh, I forgot. She's a government employee. That's a privilege. And then I said, it sounds like she's being vindictive and taking reprisals against me for my political beliefs, and the United States of America cannot commit treason, and therefore she can't possibly be representing the United States of America because Will Livingston's my fourth great uncle, and I am United States of America. And so she can't possibly be representing the United States of America, and I want her pleading stricken from the record.
Yeah, sounds like she might be a little biased there.
Well, she disappeared. I haven't heard a peep from her since. And I'll bet you another judge, another lawyer will appear. I've had that happen before, where the lawyer comes back and says, I've been transferred to another department. This other lawyer's taken over.
Oh, yeah, they give the newbie the greenhorn. Yeah, let's bring him in and let him see what happens now. Oh yeah, they do that a lot. The old switcheroo.
Yeah, for sure.
Hey, Glenn, what's your YouTube channel called? I'm trying to find it.
Sovereign Living. Sovereign Living, all one word. I'll put it in the chat.
Glenn, the
Okay.
links.
Yeah, SOVERN. They've changed the spelling.
No. There's other imitators. They don't have, I have about 40,000 subscribers. I've got the Scales of Justice. Matter of fact, what I'll do is I'll put a link to it in the chat too.
There's also
the
some
link for We
question
Are
in the
Law
chat as well, the
is-
Glen Fern room, if you want to take questions there.
Yeah, and the link for We Are Law is in your room as well, Glenn.
Yeah, Glenn, have you ever checked the spelling on that? You know how they change the language and the words and the spelling all the time. SOVERN.
I've seen that. I've seen people using that. I have no idea. I use SOVEREIGM.
Oh yeah, yeah. I was just wondering if you've seen or heard of that too. So
I've heard of it. I've seen
been a
it.
long time.
I ignore it, quite frankly.
I heard you make a terrible mistake tonight.
I did.
You referred a lawyer as not as a liar, but you said lawyer. A lawyer is a liar, Glenn. Come on, get that straight.
Yeah, I know what you mean. I've got, there's a guy from Canada. His name is Peter Riccioni, and he's a disbarred lawyer, and he got in touch with me, and so we're good friends. And he goes and he's always doing something.
What did he do? What did he do? I don't know that name offhand.
He's. I think it was all cooked up, and it's avoid judgment. But when you're dealing with the bar, they can do anything they want. And in fact, what I think happens is the good lawyers get disbarred because they don't want good lawyers. They want lawyers that are going to do what they tell them to do. And so there's a lot of lawyers that get disbarred, actually. And he's one of them. And I think that he's probably one that he's just got mixed up, and he was doing mortgage. In Canada, all mortgages have to be closed by a lawyer, and he got caught up in Calgary. He got caught up in there was a big mortgage mania that went on, and he got caught up in it, and I think that he wasn't doing anything wrong. Matter of fact, he showed me some cases that nobody else would take, that he took and won them, really good settlements. Anyways, I think he's a good guy, but they like to abuse the good guys, just like in this WFAA case that I uploaded to the group. The guy was, his name was, what was his name? Jerry Wilkins. He was a lawyer. What happened in that WFAA case is the WFAA is a TV in Dallas, TV station, and they broke into his office and put it on TV. And so he went and got a common law court judgment against him, and for $1 billion. So he probably owns WFAA TV, but I heard that he got disbarred after that. But maybe it doesn't matter anymore because he got $1 billion or owns WFAA TV or something. I don't know. But anyways, so they, when you do stuff the lawyer, the bar doesn't approve of, then you get disbarred. I even had a lawyer tell me when I told him the stuff that I do. He says, you do it because you can. And that's true. I can do stuff lawyers can't do all day long because I'm not part of their club, and they wouldn't dare do it,
Well, they can't write an affidavit, and they do it all the time.
Oh yeah. So has anybody got any more questions? We've been going for how long? Let's look here.
Just the one in the Glen Fern room.
Sorry?
One I've texted the posted the question in the Glen Fern room.
Oh, in the chat?
Yes.
want me to read it?
Which question?
About the 11th Amendment, immunity under the 11th Amendment.
Well, have you read the 11th Amendment?
No.
Well, let's put it up there. Let me put it up there. That's what Jerry Wilkins used. It went in his case, and that's why I use it, because he used it and won his case. But let me find it, and I'll put it up there, and we can see what it says. He used it. He used that exact thing. So somebody's got some kids yelling in the background. Do you want to mute yourself? Thank you. Okay, the 11th Amendment. Just a second, I got to step out. I'll be right back. Okay, I'm back. Article 11 and Amendment. Oh, damn. I pulled up a Constitution and it was the wrong one. It didn't have it was the original Constitution and didn't have any of the amendments.
I was just comparing it to the people say domicile under the 10th Amendment, so I thought that was very close. We use immunity under the 11th.
No, it's different. There we go. Okay, and I'll just share it. Okay, so let's make it bigger. Whoops, wrong way. So the 11th Amendment says the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against any one of the United States by citizens of another state, or by citizens or subjects of any foreign state. So I'm a state. And so, and that's what Jerry Wilkins, the lawyer, used in that case, in that WFAA TV case, and he won the case. So I tell him I'm the state and I have immunity under the 11th Amendment because I'm we the people. And again, that goes to also to these other cases. Remember these other cases that we talked about? This McCullough versus Maryland and Kawanakoa versus Polyblank, where it says basically the same things, that there's no right against the power that makes the law on which the right depends. So they don't have anything. Let me find those. Kawanakoa versus
While you're
Polyblank.
doing that, may I ask a question or kind of make a statement too?
What's that?
I am we the people. So I didn't write that thing though. See, that's what confuses me or makes me wonder. But yeah, we the people. I'm one of the people, but I don't call myself we the people at all.
I'm the state, and I am posterity. See, remember the preamble says that we the people do ordain and establish this Constitution for ourselves and our posterity. And so I'm posterity, and I'm we the people. Matter of fact, in my case, if you go, let's go over this first. This is the stuff that I talked about before. The sovereignty of a state extends to everything which exists by its own authority, is introduced by its permission. But does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given by the people of a single state. They're given by the people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer a sovereignty which will extend over them. I cannot give them authority over me. And if they claim there's a contract, then they're perjuring their oath. Think about it. And then there's this Kawanakoa versus Polyblank, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. So it's my authority that the government's there. So they have no authority to talk to me because they're claiming some right against me under my law. And so that's they can't do that. That doesn't work that way. And so that's why it's so powerful. What was that other case? Kawanakoa. There's other cases that talk about the same kinds of things. We the people, our rights cannot be injured by legislation or judicial authority. No, they cannot violate our rights. It's impossible. And that's why the government can't commit treason. I've had all sorts of, I used to say they were committing treason. And it was like, when they responded to that, they said it was like a joke. And the government cannot commit treason. And so they can't be representing the government because the government can't commit treason. So they're not representing the government. They're operating in their private capacity. And I want it stricken. And so I mean, that's the way you have to approach that they're not representing the government. The government can't commit treason, and I'm the government. And so I didn't give them that right to do that. And so I want it stricken. And so I do a motion to strike, and I'm doing motions to default judgment. Now at the very top of this, I don't see, it just starts a brief. But so what we'll do is we'll go to the other one that's here. Where is it? There we go. There we go. We the people. So we the people and me. And we're the demandants, okay? And at common law, you're called a demandant, and they're called wrongdoers. And so I've even seen the SEC. I saw an SEC lawsuit that called people wrongdoers, okay? So you got to call them wrongdoers is what they're doing. And so they're wrongdoers. And that's all common law. That's common law. And so that's where you have to go with it.
What about plaintiff?
Thank you.
That's commercial.
showing that.
He calls me, the judge calls me plaintiff all the time, and maybe I should do a motion of objection or notice of objection. I'm not a plaintiff. That's commercial. I'm not a plaintiff. They're not defendants. They're wrongdoers, and I'm a demandant. Okay, I can't tell you. One time when I was way back when, I was working for a company, and I got this paperwork that it was a demand paperwork. You demanded that you do this. There was a contract I was working that had something to do with the government, and I thought that it was a demand. And so we demand things from our public servants. You see what I'm saying? And say we demand or we require. It's basically the same thing. But so that's why I always put requirement and then a demandant. And so I don't want to be too pushy, but I demand. I could say I demand this court, but I say I require. It's not as pushy, you know what I mean? And then I always say respectfully submitted. And so I'm not trying to be disrespectful. Everybody has their job, and I appreciate that this judge he's not really a judge. Okay, I told him he's not a judge. He's a bought and paid for clerk masquerading as a judge, and so and he knows that's right. It's all administrative. It's under martial law. And but they still follow the Constitution. I guarantee you they're still following the Constitution, and I'm posterity in the Constitution. And so that creates a problem for them. And so I think they really do want to do the right thing. You just have to explain it to them in the right way. And that's what I try and do and I stand my ground and I object. When the lawyers come in, I tell them I object to every word they say. And if they start coming out with honorable judge and that kind of stuff, then I start calling them a Satanist because that's Masonic stuff. And Albert Pike was a Grand Master of the Freemasons, and he said in his book Morals and Dogma, he says that the god of the Masons is Satan and Lucifer. And so I start calling them Satanists. And so how do you know they're lying? Their lips are moving. So they're liars, and I start calling them liars. And I start dumping on them when they start doing that stuff. And he's hoping that there's a judge there that's one of his Masonic buddies that'll rule in his favor. So anyways, so I guess that's about it. If anybody, unless somebody has anything, we've been going on now for hour and a half.
That's been great. The information that you're dropping for us tonight is just popping. Glenn, I appreciate it big time. So I just noticed that Queen popped into the chat, so we'll give her a chance to say hello. And you have I'll send you off the audio as soon as I get it in my.
Well, I just uploaded it to YouTube. It's a live stream on YouTube. I hope you don't mind, Queen. I've been uploading them to YouTube anyways. Google was blocking me from my YouTube channel, but I figured I'd try and log in, a few days ago, and it went through without any problem. They were wanting a phone number, and I told them, it's none of their damn business what my phone number is. And so I was out of it for about 4 months, but now I'm back in, and they didn't want a phone number. I think it's because Trump got into office, quite frankly, and I'm going to sue their butt off, and now that Trump's in office, then it ain't going to go too well for him, I think. We'll see. That's all I can say. Matter of fact, he's already making noises about going after Google and Facebook and all this other stuff. So, good. So this is a live stream on YouTube, and so we've been going on for an hour and a half. So if anybody's got anything else, either that or we can adjourn till next week. Same time, same place, same channel.
Glenn, I just want to say, thank you very much. I don't tune in often anymore. I've been busy, But yeah, thank you. And I do know who you are, and I'm aware of the work that you've done, and you worked really hard for your position in your life. And yeah, you work real hard for the people. And I just want to thank you and see you maybe next time if I can come in. Appreciate you very much.
Well, it's good to be appreciated. My attitude is when I was 16 years old, I was raised as a Christian, and I got a patriarchal blessing, and it said, "Unto whom much is given, much is expected." And so I feel like I have to say something, or else I'll be held accountable. And so, it's purely self-interest. I don't want to go to hell. So I'm glad to help, and it's good to see people. What I want to see is some people get some victories, and I think that that's not too far away. Once Trump starts getting rid of the corruption, then that a lot of that stuff is going to start to fall away. And I know for a fact that over the years that they've had judicial conferences, and judges were told about what presumptions they're supposed to take and that kind of thing. And now I think that what's going to happen is they're going to have more judicial conferences, and they're going to get straightened out about their presumptions and that kind of stuff, and things will start to change. And but this lawsuit that I got, I'm suing the state bar of Texas. And what I'm telling them is I want the state bar disenfranchised in Texas and run out of Texas. And because it's nothing but an emerging dictatorship. And the judges, so far, he hasn't dismissed it. He hasn't dismissed them off the case. And this is one issue I'm prepared to take to the Supreme Court, quite frankly. I'll take that to the Supreme Court. I think that there's I filed a lot of bar grievances, and they just blow them all off as inquiries. And so I think it's more. Oh, by the way, the chief judge of the Supreme Court of Texas resigned within the last week, and I think it's because of the stuff that I've been doing. I sued him. I named him in the lawsuit, and the Texas Attorney General has come and made a couple motions to get mine dismissed off the case. And I said I responded with a motion to deny it was a motion to deny the fake attorney general, the take attorneys claiming to represent the attorney general, because they're making statements in there that they don't have authority to represent. Matter of fact, here, I got to pull this up. This is pretty good. Let me find it.
You posted that, right? In your group.
No, I didn't. Not this one. I don't believe. I might have. Let me see. I think it's this one. It's my response to the this was over Stephen McCraw. Yeah, there it is. Stephen McCraw is the Texas director. He's the director of public safety in Texas. So let me share this.
Yeah, well, you keep going. I know you've done your due diligence, and you've paid dearly for it. I've followed you for quite some time. Thanks. Appreciate this.
There we go. So let me do this. Should be easier to read. Yep, it is. So this is the brief in response to the bar members falsely claiming to represent the office of the Attorney General of Texas, and Stephen McCraw motion to dismiss, and demandant's motion to strike, motion for sanctions, and motion for default judgment. And so anyways, I go through, and a lot of the stuff you've already heard before. It says the demandant disputes every word of the bar member falsely claiming to represent the office of Attorney General of Texas and wrongfully attempting to represent Stephen McCraw. And so So, but the real good part here is down here. Says it is impossible for the 1871 United States Corporation in the District of Columbia or its subsidiary, the state of Texas, or its subsidiary corporation, Office of Attorney General, to commit treason, since Will Livingston, who ratified the Constitution for New Jersey, is the demandant's fourth great uncle, evidencing the demandant as posterity as found in the preamble as one of we the people. The demandant is a state in this union because we the people are the state. And the demandant has immunity under Article 11, an amendment against these bar members falsely claiming to represent McCraw and the County of Montague corporate thieves. And these two citations, we already read those previously. Therefore, Paxton and his bar member assistants are not representing the Office of the Attorney General or the state of Texas, and any settlement from the state of Texas is misappropriation of public funds and a felony, and the demandant wants no part of it. This all goes to the criminal intent of these bar members, because first they tax property they fail to be authorized to tax, and then they misappropriate the stolen money to deal with the litigation. They are absolutely lawless. Further evidence of their seditious communist agenda. Anyways, so I think I kind of like the way I said that. Demandant has lots of first-hand knowledge of how much Paxton and his bar member buddies love to engage in felonies, as evidence in this case and others, because their bar member buddies on the bench and off the bench protect them. Felonies in the Texas legislative inferior fake so-called courts are for the little people that are used to populate the prisons that the bar members profit from by selling people into slavery with quasi-contracts. Anyways, yeah, Paxton is in derelict of his duty because the people are king, so the Attorney General's duties are to that sovereign rather than to the machinery of government, and that's found in this case. But he's busy demonstrating he is their accomplice.
They were trying to get a less sympathetic judge. Is that what they were trying to do? Tricky.
Oh.
No, Stephen McCraw is the Texas Director of Public Safety, and they got bar members. The Texas Attorney General's trying to get it dismissed against him. Anyways, the bar member claiming to represent the Office of Attorney General and Paxton fails to have standing to represent McCraw because McCraw is being sued in his private capacity only, and they are misappropriating public funds. And this is Texas Constitution, Article 3, Section 44, compensation of public officials, contractors, extra compensation, unauthorized claims, and unauthorized employment. The legislature shall provide by law for the compensation of all officers, servants, agents, public contractors, not provided for in this Constitution, but shall not grant extra compensation for any officer, agent, servant, or public contractor after such public service shall have been performed or a contract entered into for the performance of the same, nor grant by appropriation or otherwise any amount of money out of the treasury of the state to any individual on a claim, real or pretended, when the same shall not have been provided for by pre-existing law, nor employ anyone in the name of the state unless authorized by pre-existing law. Demandant, see what they did is in their last thing they said the Attorney General can make a settlement. And I said, Demandant does not want a settlement from Paxton. Demandant wants McCraw's bond to make sure he can never again hold an office of trust. Maybe he can dig some ditches or something. He needs to be living in a cardboard box on the street like McCraw and his County of Montague thieves are trying to do the Demandant. The Holy Bible says he should get the punishment that he's trying to impose on others. Anyway, so that's where I go with it. I think I kind of nailed it right there. I guess we'll see. You just don't know. But I think I'm hitting them hard. McCraw's already resigned. Actually, McCraw resigned about the time that I filed this lawsuit because here, let me show you the filing that I did. I've got him. I'm telling you, I've got him. Big time. Anyways. I filed it into the case. Now, where is it? Oh, Where is it? It's not here. State bar. Oh, that's the state bar. That's why. So McCraw it's again talking about sovereign citizen and all that, right? And so I attached an appendix and the sovereign citizen quick reference by the Joint Terrorism Task Force. And I dump on them big time because of this stuff. And I bring up the fact that Congress went and passed a House Joint Resolution saying the people of America are sovereign. And then also they went and issued an intelligence bulletin against me saying I'm armed and dangerous, and I've never in my life even breached the peace. And so anyway, so they issued this intelligence bulletin against me. So I've got him. I think I've got him. I think that he's got a problem. He's just resigned. Hopefully I get his pension. And he's retired. He's all of a sudden decided to retire. And so they're trying to protect him. And anyways, I could read this whole thing, but that would take another hour probably. And it says here, House Joint Resolution 183 dated May 3rd, 1940 at 54 Stat 178. If somebody wants that, I can upload it to the group. I think I got it from you guys. I'm not sure. Calls the people of the United States sovereign citizens. Whereas some 2 million young men and women in the United States each year reach the age of 21 years, and whereas it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. Therefore, be it resolved. Anyways, that's all. That's the preamble to the House Joint Resolution. The defendant has never in his life breached the peace, and McCraw and his screen for low intelligence hired thugs breach the peace on a routine basis with their unlawful arrests, which are assaults, and their kidnappings under color of law. They screen their military police for low intelligence and a propensity for aggressive behavior and give them a gun and tell them to do things they failed to be authorized to do, suborning perjury. And there are court cases that talk about it. The coward Barack Obama stated in the news media he intended to murder any terrorist anywhere, U.S. citizen or not, without a trial, without due process of law, as found in Fox News article by Judge Andrew Napolitano on 7th of February 2013, and a Telegraph News article by John Swine on 6th of March 2013, and a New York Times News article by Vicky Divol on January 16, 2013, and numerous other articles. Then Obama's order followers proceeded to do exactly that, so they could complete a commercial transaction and hopefully murder anybody who thought they had rights to overthrow we the people in support of their communist coward pivot strategy in a seditious conspiracy. Patrick J. Elko, and Special Agent of the Federal Bureau of Investigation Military Police, and Conrad Rodriguez of the Texas Department of Public Safety Military Police, both of whom were part of the Joint Terrorism Task Force, visited the defendant over 13 years ago on or about the 5th of March in the year 2011, and at that time Rodriguez told the defendant 3 times that the man is listed as sovereign in their hearsay computer system. It's evidence of that as evidenced by the intelligence bulletin issued by McCraw's Texas Department of Public Safety communist as described herein. The Federal Bureau of Investigation communists used the sovereign citizen for persecution in support of their coward pivot strategy to overthrow we the people, and then circulate numerous articles stating that all sovereign citizens are terrorists, as found in an ABC News article, Sovereign Citizen Terrorist Assessment Warns of Rising Threat from Anti-Government Extremists by James Thomas on 30th of November 2015, in a news article on RT entitled As Sovereign Citizens Seen as Top Terrorist Threat by U.S. Law Enforcement by Brian Banco on August 5th of August 2014, and numerous other articles, thereby labeling anyone in the free exercise of rights and stating they intend to murder anyone that fails to go along with their communist agenda without a trial, without due process of law, by Obama and now Biden's order followers, as evidenced by the Sovereign Citizen Quick Reference, which was published by the Joint Terrorism Task Force Military Police and the Federal Bureau of Investigation Military Police communists in support of the coward pivot strategy, a true copy of which is attached here to at the appendix, and their targeted justice agenda is evidenced by targetedjustice.com website, to refuse to investigate or prosecute felonies against certain targeted people like the demandant, like the felonies these County of Montague corporate mafia are engaged in. This is all part of a separate lawsuit because the other lawsuit will include Homeland Security, military police, the Border Patrol, military police, the Transportation Security Administration, military police, and officials in the Department of State, the U.S. Consulate in Calgary, Canada, and others. The wrongdoers in this matter clearly intend the demandant turn up dead in support of their communist cloud pivot strategy and a seditious conspiracy so they can pillage the fake money from the Treasury Direct account at 31 CFR 3.363.6 under the Hague Convention concerning the international administration of the estates of deceased persons concluded on 2nd of October 1973. And if the demandant does turn up dead, this is his deathbed testimony. Anyways. Don't get me going. You're going to get me going now.
Yeah, you toned it down.
Oh my God. Now you put a copy of that in the chat.
No, he toned it down. I didn't let him put it in the chat. No.
Oh man.
I can upload.
Send it to me privately.
I can upload the Word file.
I need to use some of that stuff.
I can upload. Yeah, do it. Go check that targetedjustice.com website. It tells you all about that stuff. I'll give you the Word file.
Right on. DM me if you want. Well, that's beautiful. Thank you, Glenn.
Well, you know, I kind of get rolling, and I'll tell you, I think that one came out pretty good.
I think it's beautiful. It's true.
I'll tell you, it's true. Well, what happened is I've been filing lawsuits about this stuff. You know, since I filed, there's a bunch of lawsuits I filed in the federal court, and it's about this kind of stuff, and they got dismissed. Matter of fact, the judge I've got right now dismissed one of them, and he dismissed it with prejudice too. But now I got this other lawsuit that's bringing up. Well, actually, these issues. What happened is I was filing criminal complaints into a federal court case in Dallas that had been dismissed because I didn't pay the filing fees. Anyways, I was filing criminal complaints bringing up this stuff, and the judge sent me an order of deficiency and told me I had to file a lawsuit. So I still have to file that lawsuit. That's where I talk about it there. That's another lawsuit, and that's going to be a whole bit different group of people. But but they want to see it. They're looking for it. You know what I mean? Anyways, don't get me going. That's why. So I had all that stuff written down in other lawsuits. So all I did is I took the text from these other lawsuits and I combined it with this. You see what I'm saying?
Yeah. That judge that you said retired. Gosh, am I getting feedback?
The judge what judge? No, there was
You said one of the guys retired or stepped down, but
Stephen
now he's in
McCraw.
private capacity.
Stephen McCraw retired, but he retired about the time I filed this lawsuit. I think he got wind.
Good though for you.
Well,
is it not good for you?
You know, I don't really care whether he's retired or not. Now
he doesn't have the immunities.
Well, the Attorney General's trying to give him immunities. I'm telling him I'm suing him in his private capacity. And if I was suing him in his official capacity for acts that he did while he was in office, then he would have immunity. But I'm not suing him. Again, the government can't commit treason. So he couldn't have been representing his office at the time. He was in his private capacity. And so I'm suing him in his private capacity.
Oh, okay, gotcha.
I'm suing them all. I'm suing them all in their private capacity. So the Attorney General keeps coming in trying to defend them, and I keep doing a motion to strike. I need some more drink here.
So that's the trick they'll usually use, and they thought that trick would work, but you send it back even harder.
Yeah. Well, motion to strike, and now this it's been more than 21 days since McCraw was served, so now it's a motion for default judgment. And I already filed a motion for the court to issue warrants. against all those people in Montague County. And so this is just going to be more evidence to for them to, maybe they will. I guess we'll see.
Montauk County, that's familiar. I think Long Island Audit has some stuff against them too.
You're looking on targetedjustice.com?
No, not yet, but I will right now.
Anyways, I think we're about done here. We've been going for, getting close to, almost 2 hours now.
Okay, so let me stop the recording and then I'll ship that off to you. But I look forward to Friday nights because we get to do this. So sorry I don't have any bad jokes for you tonight.
Okay, well, thanks everybody, and we'll see you next week. Sorry?
The above the Attorney General of the United States is the Attorney General of the United Kingdom, which is the United States of America Attorney General over there in the UK. That's who the AGs answer to ultimately.
Well, the president appoints them, so I'm not sure. But I can tell you, 107's talked about this, and he's 100% right that even after we did the Constitution, that the Brits still had strings on us. And I can tell you that that's true because in the Definitive Treaty of Peace of 1783, it says that King George was Arch-Treasurer and Prince-Elector of the Holy Roman Empire and of the United States of America. And so they had some strings. 107 said in a recent video that we were in Ukraine because the Brits wanted us there. And so there's no doubt that the Brits have a lot of influence. Now, how far that influence goes, 107 is saying that we're going to have a total break with England and with the Brits, and so is Canada and Australia, New Zealand, and so we'll see how that all plays out. But that wouldn't surprise me.
But you have the King's Bench. King George's King's Bench is still in Pennsylvania Supreme Court, and the Treaty of Ghent, of course, makes a separation between United States of America and United States. And there's the King's Charter that refuses to die. You can look up that website about the charter that still exists presently until we break from them completely.
Well, the United States of America is the United States of America. That's the 50 states. And the United States is the federal government.
Okay, well, there's different definitions of the United States of America, but the Treaty of Ghent back in 1812, that was only the United States had duties under the Articles. And the Attorney General of the United States of America is the Attorney General in the United Kingdom. And the Attorney General up in Blinken, whatever, or the Garland answers to that UK Attorney General presently until we break. And so there could be something interesting going on there. Talking to him.
I wouldn't be surprised. Anyways,
there's also something called Law of the Mother Country. Law of the Mother Country. All the laws that were enforced at the time we got our self-administration. Even down here, the laws at the time where Arizona got separated from Mexico in the Mexican-American War, those previous laws or those previous flags are available for use under the Law of the Mother Country.
That's interesting. Anyways, okay, well, I think we're about done. I don't doubt what you're saying at all. I find it interesting. I've always suspected this kind of stuff, but how you can prove it, and then when you're in court, you got to be able to prove it. But anyways, thanks everybody. Have a great day, and we're going to sign off now. And we'll see you next week, same time, same place, same channel. I'm going to set up a live stream on YouTube and have it here for next week. We'll see you then.
Sounds good. You got some homework to do too now, Glenn. Okay, we'll talk to you in the week.
I do. What homework?
Well, what the acts that were just presented to you can do some reading during the week.
Yeah, for sure. All right. Take care.
You too. Ciao.
Thanks, Glenn.
All right. Thank you. Take
Talk
care,
to
you
you later.
guys. See ya.
See ya.